with the stroke of a pen foot. All these people.
Hey, Bill, Lena, Kathy. What's up, guys? Where's our judge?
At least you can say you said hi.
And so my kid was 20.
Hey everybody, welcome to American Courts. Not really sure if everybody can hear me well tonight. I'm stuck in a hotel, but we're going to do this anyways. Looks like everyone's here. We're going to jump in. We got Judge Webster, Judge Hayward, Judge Simpson, and Judge Fleischer. So let's see where we go.
That list.
Hey, Judge,
Who do you have?
can we take up this Daniel Aldridge? Because we've already got him scheduled to be out of the jail here in the next few minutes.
All right, we are on the record in 2024 TR 2440. State of Kansas versus Daniel Wilson Aldridge. Jared Regier for the state, defended in person and pro se. Let's see.
Excuse me, Judge. I know iPhone is my girlfriend. She is on my case for the bond. I don't know.
Sir,
if
you're in the middle of
there.
someone else's hearing. You're being recorded on record. That if
Yes.
somebody has transcribed this, they're going to have your conversation. Do not interrupt someone else's hearing.
I was
All
just
right.
trying to take care of iPhone.
No, sir, I know you mean well, but I've got to proceed. Daniel Wilson Aldridge is looking at failure to stop for an accident in count 1 and in failure to comply with duty to report an accident in count 2. Those are misdemeanors, sir. They carry 30-day maximum sentences and up to $500 in fines. In count 3, you're accused with operating improperly on a laned roadway. That is an infraction that carries a $75 fine. Do you wish to have an attorney on these charges, sir?
Yes, ma'am.
And are you hiring an attorney or applying?
I'm applying.
Do you have a job?
No, ma'am.
Why are you unemployed?
Because I got injured at work and then they fired me.
You have a workers' comp case going?
Yes, ma'am. I'm trying.
Are they paying any kind of temporary total to you?
No, ma'am.
You have no income whatsoever?
I have none.
How long have you been unemployed?
Since June.
And who's supporting you so that you can survive?
I'm homeless. I eat off the street.
Okay, what town do you live in?
And I got the food assistance thing. They've been helping me a little bit.
Who?
In Leavenworth, Kansas, food assistance.
Okay, so you're from Leavenworth?
Yes, ma'am. Yes, ma'am.
How'd you get
Are
here
y'all gonna
today?
pay for my gas when this gets found not guilty and stuff, like to help me to repay these people I'm owed money for bringing me down here?
Who?
My
Who
girlfriend
brought you?
brought me here. My girlfriend.
Okay, so your girlfriend has a valid license and brought you down here?
Yeah, I got a valid license.
Okay, so I'll appoint attorney Darren Patterson and the officer will give you his name and number. You should have written it down when I told you to, though, at the beginning of the docket. Make sure you go directly to his office across from the courthouse. Your court date will be Monday, January 27. You must be here at 8 a.m. by Zoom. But you make sure, Mr. Patterson, you said you're homeless. Make sure Mr. Patterson can find you. Give him some kind of contact where he can find you, whether it's your girlfriend or whoever.
All right, excuse me, miss. You said be here by what, though?
8 a.m.
On that day?
on that day.
Okay.
Your bond will be set at 2,500 OR.
Okay.
Anything else, Mr. Regier?
Your Honor, I'm looking at the ticket in this case. Notwithstanding the nature of the charges, this does appear to be a case involving a series of infractions and misdemeanors. I'm Class C and unclassified misdemeanors, rather. I'm not sure how the court feels about that, but if that is the court's order, certainly I will put notes in the file to that effect.
All right, make it a 1,500. Those are still pretty serious, leaving the scene of an accident.
Very good, Your Honor.
Too.
So I'm saying, are y'all gonna reimburse me when I get found not guilty? Because there was no accident.
All right, well, you can talk to your attorney, Darren Patterson, about that.
You're the judge. That's why I'm trying to talk to you. Put it all
Come
right
back
now, man.
here, come back
I
here,
ain't feel
come back
sorry.
here,
Man, what?
come back here, sit down, put yourself in front of the screen and listen to me. I'm not gonna put
Yeah.
up with attitude from you. You wanted a court-appointed attorney. I
Thank
gave
you.
you an attorney at the taxpayer's expense. I gave you a good attorney, but he would tell you this is not the time to offer your defense. This is the time for you to go to him. He will help you discuss your case and decide if you have a defense. And if you do, he can put it on the trial docket. I will probably be your judge, and I will judge the evidence and
Okay, thank you.
decide. All right?
Yes, ma'am. Thank you.
You're welcome. Now, you don't leave until I tell you to.
All right, that's what you're doing.
Get that attitude in check, and we'll get along a whole lot better.
Yes,
All
ma'am.
right. Now, do what the officer said for your picture and prints and go to Mr. Patterson's office and make sure he knows how to get a hold of you.
Yes, ma'am.
All right. You may go, sir. Thank you.
All right, thank you. Have a great day.
Hey everybody, I wanted to jump in again and just say hey there. Let's see if I can get two of me off the screen. There we go, back to one. Just want to say hey to everyone. Had a chance to catch up a little bit on there. I wasn't sure the audio was going to work, but thank you guys so much for coming out. We missed you the last two nights, so thank you for joining us on this and not giving us too much. ATX Alley is on her way to Home Depot, so she's not able to jump in the chat there. Debbie, she wasn't missing your comments on purpose. She's just driving in. I told her not to text and drive. We kind of help each other out like that. We're going to jump into one where the guy accuses the judge of being racist, and you make your own call on it. But I kind of feel he's being a little petty, so let's see where we go there.
That desire, I thought that you wanted to continue with Zoom, but I'll keep that in mind moving forward here. So this is the date set for a pretrial. Couple of things. The court was in receipt of a letter from a Todd Nadeau, a clinical director at Performance Psychology. Defense counsel, have you seen and reviewed that letter?
Yes, Your Honor.
Yes, Your Honor. And I asked my staff to forward that to Mr. Klusny. Mr. Klusny, did you get a chance to look at that?
Yeah, I did get it, I believe late this morning, Judge.
Okay, so it clearly indicates some ongoing mental health treatment that Mr. McCall is undergoing. I won't go into the specifics, but just to say that it does put into writing the statements and representations that Mr. McCall had made at the last hearing. So I reviewed that. The court brought everybody in today, though, because after our hearing late last week, the court had a chance to kind of further consider the arguments and the statements that Mr. McCall had made on the record. That prompted some concern about Mr. McCall's ability to understand the nature and object of the proceedings that are going on against him here in this case, and his ability to assist in his defense in a rational manner. Because of those concerns, the court did look into some of the past correspondence that Mr. McCall had sent the court over these many months while this case has been pending. And that brought up further concerns to those 2 points that I had just stated. Mr. McCall has continually seemed to talk about some coordination efforts between different government agencies here at the city, the court, the police department. Seems to be linking some of the past things that have occurred with Mr. McCall and those agencies into this proceeding. Things that just, again, concern the court enough to where I think at this point it is appropriate that the court refer a competency evaluation here for Mr. McCall. So that's what the court is going to do on its own motion.
May I speak on my behalf, sir, Your Honor?
I'll let you address the court here in a second, Mr. McCall. I just want to finish.
Okay, yeah. I just know
I
the
need to
real
do.
but I'm sorry. Go
So,
ahead.
you know, I know that this comes with its own response, I'm sure, from Mr. McCall. I just want to reiterate, I don't think the court has much of a choice here. Looking at the court rule, it appears to be mandatory once these concerns pop up in the court's mind. The court needs to have one of these evaluations done. And so that's what the court is going to order. And I'm going to ask Mr. Kaluzny to prepare that order and submit it to the court so that I can sign it and have that start going. Because of that, I think it does a little bit to our timeline. So last time we were here together, we set a jury trial in January. I'd still like to keep that January trial, but I do acknowledge that it's probably a bit hopeful to think that we'll have that report by then. But what I'll do is just set a pre-trial in a week or two ahead of that trial date, and then we can come together and hopefully have a response from the forensic center. But if not, then we can make some adjustments at that time. So I put that out on the record. I told Mr. McCall I'd give him a chance. You know, Mr. McCall, you still have the absolute right to remain silent throughout all these proceedings. You have two attorneys here that can speak on your behalf. But it sounded like you want to say something, so I'll just leave it at that and allow you to say something if you wanted to. But I don't know if counsel wants to say something first or not.
Yeah, if my counsel wants to speak first, they can. I don't care. I just think this is unacceptable.
All right. It looks like they're just. Oh, go ahead, Ms. Koskos. About to say.
Your Honor, the court has ordered what it has ordered, and so that is what it is. I will say I think that January trial date will likely have to be moved. I think on someone who is out of custody. I mean, it's taken about 3-4 months on people who are in custody. The only thing is, Mr. Kaluzny, when you do the order, if you could just kind of keep track of it at the forensic center for us, because sometimes what happens is they'll notify the client and not us of when they need to report. And sometimes it's the other way around where they'll notify either Mr. Rangout or me and not the client. So if you could just kind of keep on track of where we might be there. Sometimes they're more likely to answer the prosecutor's calls about that than ours.
So let me ask you a question now.
Go ahead, Mr. McCall.
So you're trying to take me into custody for stating the facts of what happened inside of the hospital.
Mr. McCall, you are not going to
take me into
nothing is
okay. Well, take me into a competency exam. Extend this even further. When the thing is that, you know, if I am incompetent, it's because of racism and discrimination. If you have a moment, or if you will, if there is a sign of me acting maybe out of myself, it's because of racism, discrimination, and being assaulted. It's offensive. I don't feel I need to go inside a center. I don't feel I need to even sit down and speak with anyone regarding this.
No,
These things are established facts. May I finish, please, Judge, Your Honor? These things are established facts. What I've stated, I'm not going to sit and lie to you. I'm not going to sit and pull something out of left field, right field, ball it all up and say, hey, that looks good, and throw it to the court. What I've spoken is true. And to go through this, to have my word to be, shot down when I've been a law-abiding citizen, I've had no issues with the law. I'm 47 years old. Haven't had any issues with the law outside of them placing their hands on me when they shouldn't have. I haven't had any issues with any people outside of them placing their hands on me when they shouldn't have. I'm not out beating anybody up. I was a CPL holder, a lawful gun owner, and all of these things are being made to look a certain way so it looks good for one side or one group, and we know what side and what group that is, and to make it look bad on me. If this is what's going to go on, I'll just excuse myself from this proceeding and go ahead and, because I am with the, I'll excuse myself from this one, and then I'll speak with the Attorney General for the state of Michigan, go back to Washington, speak to the Attorney General, speak with the Secret Service, and also continue on with the Department of Justice. I shouldn't have to say that in this hearing in front of everyone, because I do not want everyone to know that there is a pending case with the Department of Justice or the Attorney General once I complete everything with the Michigan State Attorney General. I did not want to go ahead and do that because that would have possibly interfered with the Department of Justice interview. So everybody knows everything now. I'm not bluffing. I'm not making anything up. I'm upset because, again, racism, discrimination. I could go see Dr. Todd, Dr. Phil, Dr. Nandi, it doesn't matter. I could go see them all. There is no cure for racism and discrimination or perception or for someone who perceives they're being treated in that manner. And I know it's greater than me being perceived to be treated in that manner. As I'm 47 years old, I've had an experience with it over 45 plus years.
All right,
I learned certain words in kindergarten and in elementary and preschool that most kids today don't learn until they're much older. And
Mr.
it
McCall,
wasn't from my family.
Mr. McCall,
So let's
I'm
not
gonna end with this, Mr. McCall.
here's the thing, Judge. Judge, here's the thing. I'm not a bad guy, and I'm not the bad guy in this. So I want a competency exam on every police officer that sat there and lied and said that I've threatened to kill 3 police officers, which kind of front-loaded this thing to get another judge to say, oh, we need to take away his rifles. Oh, we need to do this so we can gain entrance into the home, which they were already going in and going through the thing. So the only entities that were involved with this that I've stated from the beginning, Oakland County Sheriff, Royal Oaks Police Department, and you can also include the City of Detroit and also the Beaumont Hospital staff. That's the only one, which are some of the City of Detroit police officers. But that's the only people I've said. I'm not reaching out of left field. I find it offensive. I find it unacceptable. I find it, it's egregious. It's disgusting that I've got to go through this. Hey, the sky's blue. Well, we don't know. I think you need a competency exam. The sky's blue and has white clouds. Well, I don't know. We need to look at this. The sky's blue. Okay, it's storming. The sky's green. The sky's gray. Oh, we don't know. We don't think so. You're not going to take my word for anything, but you're going to take the word of those lying peace officers.
Yeah,
you guys take that word. Hold on, sir. Please hold on.
I'm going to give you another couple minutes here, Mr. McCoy. But
that's fine. I'll wrap it up quickly, sir. I'll wrap it up quickly. But like I said, you take the words of these officers, that attorney who doesn't know anything regarding me or regarding this situation or regarding this case. No one has looked at the facts of the statements that I've made. No one looked at the letter from CPS. No one looked at the investigation from CPS. No one looked at the investigation or the letter that my wife wrote that I had. People wrote letters stating of what happened that night. I asked a white woman to leave my house over 10 times. If you don't leave, please just step outside to calm everything down. But please just step outside. And here I am, 8 months later. I didn't put my hands on anybody, didn't spit, kick, punch, intimidate. I didn't do anything. And I'm sitting here going through this. Oh, we think you need a competency exam now. So what's that going to do? That's going to take the stuff you guys played, your officers lied, and put stuff out there to the newspapers and all these groups, armed standoff. Well, Mr. McCall didn't have a gun in his hand. Barricaded gunman. Mr. McCall didn't barricade himself in that house. I'm not afraid of now one of you. I went outside and talked to the man. I talked to the police. I talked to your officers. The police officer, I believe it was Kaufman, or his last name starts with a K, the one that tried to break down my door unlawfully. That one I did. I told him to get the heck off my property because he tried to break my door down with no provocation. There was no lawful purpose for him to be there. Oakland County Sheriff, same thing. I spoke to him. He said there's no lawful purpose. I said I agree. So go ahead and you guys go grab something to eat and get up out of here.
Right,
like all of this is
its ruling on this issue. It's really not about the facts and circumstances of the case. It's about the concerns that I just went over on the record with regards to the communications that you've offered.
Everything
on the record.
You guys don't understand English. You don't understand English. I sent it in Arabic. You don't understand English. I sent it in Espanol, in Spanish. I'm telling you the truth. If you don't understand English, I can send it in Ukraine. I can send it in Russian. I can send it in multiple languages.
All right.
If you guys aren't going to understand English and aren't going to listen, then I will, like I said, I will hop on a flight. I will go to Washington. I'll get a court order from Washington. I'll get a court order from the Department of Justice and let them deal with you guys in that city with your issues and not mine. We'll have a competency exam on all of you, and we'll go from there.
All right, we're all set for today.
I'm not playing with any of you. Judge, I have respect for you, Judge. Judge, I have respect for you, sir. I'm not playing with any of you. I'm going to let you know that now. This is tyranny and oppression, and if that's the route we're going to go, the Constitution speaks in a language I love to speak in. If you read the letter about who and what I did and who I was, that letter will let you know if you read between the lines. I love it.
All right, Mr. McCall, if you just let Mr. Angat address the court here. Go ahead, Mr. Angat.
Thank you, Your Honor. Judge, just for clarity, may I have, or may we have both the court rule and the statute to which the court is relying, or upon which the court is relying?
Yes.
And I believe it's MCR 6.125 and MCL 330.2020 et sec. The statute itself covering the reasons why the court may on its own require this type of competency examination. It seems to be a two-pronged test. One being that the defendant is determined incompetent to stand trial only if he is, one, incapable because of his mental condition of understanding the nature and object of the proceedings. Judge, I would argue, and I think Ms. Krauskopf would agree, Mr. McCall has a full understanding of the nature and objects of the proceedings against him, or the other prong of assisting in his defense in a rational manner. Just so the record's clear, Judge, we have spent, I will say at least point hours with Mr. McCall, both live, in person, on Zoom, through various written communications, and I do not believe that he falls into either of those prongs. I believe he is absolutely understanding the nature and object of the proceedings, and that he is able to assist in his defense in a rational manner. I just want to make that record clear so we do have a record of our position.
Mr. Angot cited the appropriate court rule. I was addressing as terms of statutory authority that the court has. It's 330.2024, which indicates that the issue of competence to stand trial may be raised by defense court or prosecution. The court here in this case has raised the issue of competence on its own motion. Neither defense nor prosecutor has made that motion, and obviously Mr. Angot here arguing against the court doing what it has done today. But I think Mr. Angot does also cite the appropriate statute with regards to the two-prong test here for the court to consider. And the court made its record. That was the start of the hearing. I talked about the specifics. Has nothing to do with the facts and circumstances of the case, because as of yet, we haven't gotten to that point. It's only based upon the communications that I've seen here in court and the written communications sent in by Mr. McCall that the court's making this determination here today. So that's going to wrap it up for today. And then we'll get notice of our next dates out. Mr. McClusney is going to send in that order for the court to sign.
Judge, would you consider removing the tether based upon the correspondence you received from Mr. Nadeau?
Do the people have a position?
Judge, I mean, obviously I looked at the letter briefly. To me, it doesn't provide any specifics. It's just broad statements. There's nothing specific as to what exactly is going on and how often. And that was my issue with the letter.
Right. I understand the issue with the letter, but do you have a position with regards to the tether requirement?
Judge, I think part of the issue is understanding what the treatment currently is and what's happening, and I still don't really fully understand that. And based on that, I don't think anything should be changed.
The only thing I would, if I may, Your Honor, the only thing I would add is that both the May letter and this November letter, almost 6 months apart, claim from Mr. Nadeau, the therapist, that Mr. McCall is not a threat to himself or anyone else.
So here's the court's reading on this. And I agree with Mr. Angot. The letter from Mr. Nadeau does indicate that Mr. McCall is neither a threat to himself or others. There's also been this. The tether dates back to March 26th. Mr. McCall has not had any violations of the tether provisions for all of that period of time. The concerns that the court brought up here today have been present throughout because in part the court based its ruling on communications that Mr. McCall has sent throughout that period of time. Mr. McCall is apparently treating with Mr. Nadeau in addition to others. I don't see a basis right now to continue on with the tether. So I'm going to amend the bond conditions to remove the tether. However, I'm going to alter some of the other specifics of the conditions of bond. So in lieu of the tether, I'm ordering weekly phone check-ins with pretrial services. I'd like also monthly updates of ongoing mental health treatment that Mr. McCall is engaged in, both with Mr. Nadeau, and he's mentioned 2 other doctors now to this court on 2 separate occasions. So I'd like continuing updates from those additional doctors if he's treating with them. They should provide updates. All other conditions will continue, which includes the no contact provisions. And I should also state, he's mentioned other proceedings, other ongoing court issues. If there is any other court orders out there, this court amending its bond conditions has no impact on any other judicial order, any other court's order, which may be in place. So those things, if there's another court that's ordering a tether, then my removal of the tether provision has no impact on that.
Am I allowed to go hunt? Am I allowed to go hunting to provide for myself at this point, because I'm being taxed on everything, Judge. I'm sorry to cut you off. Am I allowed to go hunt and provide for myself, food for myself? Or is the court going to provide lunch stipends?
No,
Dinner stipends?
I'm not doing anything with the condition that you not purchase or possess any weapons or firearms. That's staying in place.
So that's to back things up. That's probably the reasoning for all of this. Like when the police officer was following me in the sporting goods warehouse and also Dunham's, and I have video of that I sent over to my attorney. But that's probably why he was doing that.
Mr. McCall.
Joseph Kutznick, Officer Kutznick, the one that looks like Caillou, the bald head guy. That's why he was following me around, and he was the one inside of my house with my wife. Is that why? Is that?
I muted Mr. McCall because he will not relent when the court is trying to explain its ruling. That's where he brings up questions. The provision or the prohibition of purchase, possess firearms dates back to the nature of this particular charge. It has absolutely nothing to do with any of the other issues that Mr. McCall brought up. So that's the court's current amendment to the bond. We're all set for today. Okay, we're off the record on this case.
Okay.
Yeah, that was a wild one there. That guy blamed everything and everyone. I liked at the end how he asked if they weren't going to give him his guns back if they'd give him grocery allowance. That was kind of funny there. He had a domestic charge. It had something to do with walking in on somebody at home with his wife, and threatened to unalive a few police officers. And he had a good little story going there. So he doesn't need to have any weapons right now. He needs to get through this court trial. Just another one of Judge Hayward's. She's one of my favorites, and so let's see where she's at.
Mr. Lynch, I'm sorry, Mr. Taylor. So Sonia Clayton, she's related. She's involved with DFACS.
She is the foster parent. She's the foster parent of Miss Johnson's children. I believe Miss Spalding was the DFACS worker. There was an incident, and this is roughly 3 years ago, an incident while Miss Johnson was having visitation while Miss Clayton was present. The children are still residing with Miss Clayton. Is that correct? She is able to have visitation now. She goes through her mother to arrange the visitation with her children at that time.
Okay, let me, the second one, Michael Wilson. Who's Michael Wilson?
That's Mr. Johnson, Miss Johnson's father. And there was a verbal altercation between the two. I think if this is a scenario or a situation where, yes, Miss Johnson sprayed pepper spray. She had reason to spray the pepper spray because there was an altercation with her father being aggressive towards her. She left the scene, so the only information that the officers were able to receive were from her father. And we're not disputing that she sprayed the pepper spray. That's why we're entering our plea today. But the situation is not where Ms. Johnson was the actual aggressor in the situation.
Ms. Johnson, come forward, talk to me. Let's see what's going on. Mr. Taylor, is there a mental health issue that I should be aware of?
I don't believe so, Your Honor. I've been speaking with Ms. Johnson, and she's perfectly.
Hey, Deputy Woods.
Hi.
Okay, go ahead.
And very articulate.
All right, Ms. Johnson. Okay, let's talk first about what's going on. Why are your children not with you?
Okay, yes, ma'am. I need to find housing. At the time, I had just had my 7th child, and my rental lease was up, and so I have to find a new place for them.
Your 7th child?
Yes, ma'am. At the same time of my moving off of my rental lease, and so I just have to find a housing for them.
Are you on a DFACS reunification plan?
I was, but due to the shutdown, it's been the department has been closed, so I've been trying to find someone to speak with about.
No, ma'am. DFACS never closed. I used to work for DFACS, so I'm clear on how this works. So
Human resource place.
no, the reunification plan is something that you come up with the social worker and DFACS manager at the division that handles your children. That they
Fine with that. I mean, everything's okay. I visit with them once a week. Everything's okay.
Okay, so no, that's not okay. You don't have your children. They're in foster care. I'm trying to figure out how we get you back to a roll call straight, as it were. Then now who are you living with?
I'm living with my mom right now. Yes, ma'am.
Okay, but your mom is not the person who has the children.
No.
And how old is your oldest child?
She's 10.
You have 7 children, 10 and under?
Yes, ma'am.
Are there multiples?
They're all a year apart.
Is there a father involved?
No, ma'am.
How old are you, ma'am?
I'm 34.
You're 34.
Yes.
And that presumably means you're still fertile. Can we avoid having any more children until we can get our life straight?
That's my life. It's good.
I can't hear you.
My life is good. It's just with the timing with my
Ms. Johnson, what you're not gonna do is lie to me, because you got 2 cases pending before me, and the one is a 2024 that happened in November. So no, ma'am, you're in a green jumpsuit. Your life is not good. Your children are with somebody else in foster care. Your life is not good. So let's not gloss over what's going on.
Right.
Are we sure there's no mental health issues, Mr. Taylor?
I can't speak absolutely to that. I've just met Ms. Johnson, as I told the court earlier. She's very articulate and seems to be functioning well. I don't know outside the courtroom if there's any other issues that aren't.
Ms. Johnson, my fear is for the children at this point. The last thing I want is for you to have more babies for somebody else to take care of. Are we clear? Are we clear?
Yes.
Because that's not fair. If you have the babies, but then they go to somebody else for them to take care of, you're just having babies, but you're making your kids don't have you as the mother in their life. You see them once a week. And number 2, you're making a hardship for somebody else to try and keep 7 kids. And number 3, if you have siblings, they should be raised together. But if you got 7 kids, it is hard to keep 7 kids together. Imagine what your 10-year-old must be thinking, like, I'm in foster care, I got all these siblings, I'm the oldest one. I don't have my mama. She sees me once a week, if possible, but you've been in jail, so you haven't seen him since you've been in here. Miss Johnson,
Do you have any
The-
resources for me?
the what?
She asked if there's any resources available, if the court could provide any.
Ooh, Miss Johnson, I wish I knew.
Okay.
I do know that condoms are cheaper than child support or child care, and you don't have to keep having babies. Let's start there. Can we start there?
Yes.
Can we commit to not having more babies right now?
Yes.
I mean, babies are a blessing, but that's if you can take care of them and make their lives good. You're not doing that. You're just having them, but you're not blessing them with a good life. You get me? So my concern is for them. But when you keep telling me life is good, everything is good, but you don't have your children, they're in defects, you see them once a week, you got 2 battery cases in front of me, that's not a good life. And Mr. Taylor can't tell me, but something must be going on.
Mm.
When was the last time you had a job, ma'am?
Yes, ma'am. I'm taking online classes at Southern New Hampshire University.
Okay. You saying what now?
I'm a student online at Southern New Hampshire University.
Okay, ma'am. I've been a student in person and still had a job.
Okay.
When was the last time you had a job? Stop telling me what you think sounds good and talk to me straight up. When was the last time you had a job?
I work for myself.
What are you doing?
I do hair on the side.
You do what?
I do hair sometimes.
What you do to it?
I do braiding, sometimes washing sets. I mobilely travel to the clients or they come over. Yes, ma'am. That's right.
So you're a kitchen beautician?
No.
Do you have a certificate? Do you have a license?
I have my, what you say, license?
Yes, ma'am.
Beautician's license.
Beautician's license. No, it's not a license.
So you a kitchen beautician?
No. No.
What do you mean, no, ma'am? If you don't have a licensed if you're not a licensed cosmetologist or beautician, then you just catching as catch can.
Okay, last time I had a job was about 4 months ago.
What were you doing?
I was working at Subway.
At what?
At Subway and Carrabba's. Server Carrabba's.
Okay, so you're gonna go back to fast food?
More than likely, just something light until I finish school.
Miss Johnson?
Yes.
What you taking in school?
Teacher education.
Miss Johnson, I'm gonna tell you right now, with this record, that's gonna be hard for you to get into a school. You got battery cases, ma'am. What you need to do is go back to school and get you a hairdresser's license so you can go ahead and do somebody's hair. And at least that'll be money coming in. You can work for anybody who has a shop open or a chair open, and you can run your business. I'm doing teaching education at Southern New Hampshire. First of all, those programs are expensive. So I'm wondering where you're getting the money for online education. Second of all, you're telling me what you think makes it sound good, but you are 34 with 7 kids and your kids are in foster care. I'm going to need you to get on the thing that's going to bring some money in as quickly as possible.
Yes, ma'am.
Otherwise, it doesn't sound like you plan to reunite with your children.
Yes, ma'am.
When I say, are you on a reunification plan with defects and you tell me the office is closed? No, ma'am. We clear?
Yes, ma'am. Clear.
All right. So on the case ending in 07702, 12 months probation, 40 hours of community service, a fine in the amount of $300 that will be suspended because she don't have the money. anger management and no contact with Sonia Clayton. If she has been having visitation, that's going to end her visitation. Are we clear? Are y'all aware of that? Had y'all thought about that?
We spoke about that, Your Honor, and she had been arranging visitation through her mother. She wasn't.
I get arranging through her mother, but if DFAC says these children can't leave Sonia's care, then she can't see her children unless her mother has the right to get the kids and supervise visit. See, y'all got to think through these things. If her mama doesn't have the right to take the kids out of the care of the foster person, then she won't be able to see her kids.
Yes, Your Honor. You understand that?
Yes.
Okay, and the other thing, to run concurrent with 2024 CR 09340, 12 months, 30 days, balance probated for you to take an anger management class. It's the same class. You don't have to take it again. A $500 fine, suspended, 40 hours of community service, and no violent or harassing contact with Michael Wilson. Now, who's your mom?
Her name is Georgia Johnson.
And you're going to be able to go live with her?
Yes.
Okay. Miss Johnson, you got to get yourself straight. I don't know if it's alcohol, drugs, but something is keeping you from having the life that you need to have. But I beg you, ma'am, don't go get pregnant again. How old is your youngest child?
She's 3.
Don't go 10, 9, 8, 7, 6, 5, 4. Ma'am, don't go get pregnant again. None of these babies have had time with you to have the amount of nurturing that a mama is supposed to give. Not one of them. Not one of them has spent a whole year being nurtured before you have another baby. Not one. Not one of these babies. Please don't have no more children. And I don't care if people say it's bad. I don't care what people say. Don't have any more children that you can't take care of. Are we clear? You can have all the sex you want as long as it comes with a condom or some way to prevent you from making another baby. Are we clear? Because I'm not convinced that you're not doing some form of sex work. We got 7 kids and no man is involved in their lives? None at all? Think about what you're doing, Ms. Johnson.
Okay.
All right. You can go back with the sheriff's office.
Okay, thank you.
Thank you, Your Honor.
I love this judge. I'm actually convinced that she's probably one of the best judges in the country, and definitely the most underrated one. Definitely the most hidden one. She does a damn good job. I love seeing her stuff, and she agrees with Victoria, and that's all that matters. So, speaking of Victoria, let's see. Let's go. Speaking of Victoria, she wanted some Judge Simpson today, so let's try that.
Your Honor, we're going to ask for a preliminary exam at the earliest convenience.
I don't think that that's appropriate at this time. Defense counsel asked me this morning to get media discovery because he only has paper. I informed him of the proper procedure on how to get discovery from our office, but he is not in receipt of that yet. So I don't think it's appropriate to set today.
So all discovery is not complete.
I have the paper, Your Honor. The digital, I do not have.
You do not have the, okay. Have you requested it as of yet or not? That was just a discussion this morning.
Yeah, I did, Your Honor. I did request it to Ms. Pouzan. She informed me.
Okay, how fast is that going to go out then?
My understanding is as usually it's the same day.
Same day. Okay, so if he does it today, here's what I'm going to do. I'm not going to set the preliminary examination because discovery is not. Go ahead, sir. What do you want to tell me?
Sir, I just wanted to say I've been in jail for 60 days because we've been trying to receive a discovery. And it's like the more you're journeying and push it.
What do you, What do you mean you've been trying to receive it?
Like,
Well,
like I
Mr. Glover,
came,
hold on for a second. Just let the judge do his process first, then we can talk.
What I was gonna do is I was just gonna adjourn it out 1 week so that all of the information is there. I don't know what,
Your Honor, before we set a date, I do think potentially I should address a bond issue first.
okay. All right, so I'm going to adjourn it, but I'll let you, go ahead. What do you want to tell me?
Your Honor, the defendant has called the victim over 300 times. At this point, he has made comments and had conversations with the victim, including things like instructing her to come to court and not let anybody but the defense attorney know that she's there. And he said, they don't have a good phone number for you for nothing, so you don't even need to bring a phone. Just be there in the crowd of the courtroom and let my lawyer know you're there. This lines up with the fact that Mr. Dox has informed me that the victim was going to be present in order to address the court to say that the allegations are false. At this point, I am very concerned about the nature of these calls. Given that there's 300, I haven't had a chance, over 300, I had a chance to listen to them all. My interns haven't, but there seems to be serious grounds for forfeiture here. So I think in order to ensure that Mr. Glover has due process, as well as that we're proceeding in a allowed to do our due diligence, we need a bit more time.
Okay, and so outside of the other discovery, that information is also going to be provided to defense counsel, the phone
Yes,
calls.
and that is not going to be able to be sent today because it's my understanding he's used over 8 other inmate pins to make these calls. So it's not a matter of me just sending one email to Miss Doherty at the jail to have them all released. I have to go in and download them each individually and then manually send them over to Mr. Dox.
All right. Counsel, you have anything to say regarding that?
Your Honor, I believe that the complaining witness in this case, as I alluded 2 weeks before, has been trying to call my client, Your Honor. She is there not to, on her own volition, Your Honor, just to say to the court, not to talk about the case, but that she is not afraid of my client, Your Honor, that she has not been threatened by my client, and that she would like the no contact order to be released. That is to my understanding. And she is in the courtroom right now.
I think that's my concern too.
You think she's here now?
Yes, Your Honor.
There, Kaylee Loveday?
Yes.
Okay. So normally, and ma'am, is it correct that you're coming down to ask me to lift the no contact?
Yeah.
All right. So here's the way I'm going to handle it, because normally what I would do is I would hear from her, be assured myself that it would be proper to do so. The problem now that I have in this case is that the people have indicated these 300 calls in which the defendant is not to be having contact with her at all whatsoever. But these 300 calls lead the court and the prosecutor's been frank, she can't get through them all, but it's leading the court to believe that there's some manipulation by the defendant regarding this particular criminal proceeding. And so, ma'am, with all due respect, you may or may not be involved in it. I'm not making a determination at this point in time. I'm not going to hear from you today. I'm not changing any of the bond conditions. I'm not changing the bond conditions regarding contact. I am revoking in its entirety the defendant's phone privileges except for communication to counsel. So he should not be talking to anybody from the jail unless it is his attorney. And I've signed that order already. So I'm I'm changing that. The other issue that comes up is she's here today, but I don't know what was said. And by the time we get to preliminary examination, if she's not here, the people rightfully could then proceed by forfeiture. They could also do so, and there may be issues regarding any testimony that she might give if it is inconsistent with other testimony. I'm not going to go through all of that. I will just say this. Sarah, I appreciate what you're saying in terms of it discovery, but it seems to me some of the discovery you're creating yourself, and that has to get over the council. So that delay is you.
Yes, sir.
So here's what I'm going to do so that.
Or no?
Yeah, I'll let you talk to me, but
No, Mr. Glover.
you're probably
No,
talking
Mr.
too
Glover.
much.
Yeah, no, Mr. Glover. Go ahead, Your Honor.
All right. So probable cause conference, I will. So, dear goodness, that the one part of the discovery is going to get to council probably today. How long, and I'm not going to hold you to the exact thing, but how long will it take to get the phone calls to him, you think?
I will do my best to get it to him in 2 weeks. I don't think that I'm not gonna be able to listen to them in 2 weeks' time. I can say that for certain. I'm not sure that I need to listen to them all, but I think assuredly I can get them to him in 2 weeks.
Got it. Okay. So given all of that, then I'm going to set. Comes out in 2 weeks.
Your Honor, can I?
Council, would you?
No, Mr. Glover.
Yeah.
One more time. You have a chance.
I just don't want to go to court. I just don't want to be pushed back so far. I'm trying to.
You know what? I don't want it to either.
Yes, sir.
But you've also got an attorney that's got to do his job. Your behavior, if true, is making it infinitely more difficult for him to do that.
Yes, sir.
If you stop doing what you're doing, there is not a doubt in my mind that your attorney would be ready to go.
Yes, sir.
So don't be complaining that you don't want anything pushed back. Don't be complaining about any of that. Stop doing what you're doing.
Yes, sir.
Counsel, if those come out in 2 weeks, so just so that they at least get to you and you can look at them, and then we can certainly go from there. Then the next date I have for a probable cause conference after that is the 26th. Are you available?
Yes, Your Honor.
The day after Christmas? Would you be able to do that, sir?
Yes, sir. I'll be via Zoom, but I'll be out of town, but I can do it. Yes.
Okay. Now, adjourn the probable cause conference to December 26, 2024, 9 a.m. Defendant's bond will continue. The changes, all of its phone privileges are revoked. Thank you.
Your Honor. Thank you.
Well, it seems like they're going to do court the day after Christmas, so we all got that to look forward to. I guess they're going to take off the 24th and the 25th. I don't know what the dates show up on the calendar as. I don't know what day of the week. If anybody y'all know, put in the comments real quick if Christmas is on a weekend or a weekday. I didn't even pay attention. My world doesn't revolve around that, so it don't ever really matter. I'm gonna call it quits for tonight. It's been a long week. I gotta get back to work in the morning. We're gonna try to do it again tomorrow night. Thank you so much for tuning in, and we will see you tomorrow night.